advanced as a society, the criminal justice system has been required to carry an increasing amount of the weight of some of the dysfunctional side of our development. Yes, Mr. Speaker, we've done very well over the years in terms of healthcare, in terms of education, in terms of social services, and all of these indices, Barbados has done well. But our society has perhaps become a little fractured along the way, and therefore we are seeing, Mr. Speaker, an increased involvement among our young people, especially in the criminal justice system. I remember growing up, sir, just under Charles War Bridge, at a time when Buddy was the menace to the Barbadian society, Buddy Braffett, a man from Ellerton, I believe. So that would give you an idea of what I'm talking about, sir. And even though we had people like Buddy Braffett throwing dynamite at police and running police and all kind of thing, there was no feeling, sir, that our society was beyond redemption. Our societies were still cohesive. In those days, we had youngsters who would get off the bus in Charles War Bridge, but who seemed to have a feud against the men from Ellerton. So the moment they get off the bus, rocks would rain down the bus as that bus headed up to Ellerton, and vice versa. We look back on these things now almost as part of Barbadian folklore, and we think, what a wonderful society we lived in those days. Perhaps when history consigns the 2020s into the distant past, we will probably find some folklore associated with this present moment. I hope so. But what we do have, Mr. Speaker, is unfortunately a situation where, because of the inefficiencies of our criminal justice system, Barbadians have begun to doubt whether it is effective in helping to deal with the challenges that we face. You know, Mr. Speaker, one of the greatest things that will weaken, or one of the things that will weaken a society's resolve more than anything else, is when that society begins to lose faith in our institutions. And there have been a number of things, sir, in the last few years that I think have caused Barbadians to wonder whether the system, the legal system, the criminal justice system, is working in our favor. You only have to think about the revolving door that is Glenderry, or Dodds. You only have to think, sir, about the fact that people have been able to get out on bail who are on multiple homicide charges, things that never used to happen before. You can reflect on the fact, sir, that as you open the daily papers or the daily paper, cases are being brought up to be tried for incidents that took place 10 and 15 years ago. The memories of the witnesses have grown dim, and you have to ask yourself whether justice is being served by trying to stretch somebody to remember exactly what happened at 2 o'clock in the morning in the year 2007. I perhaps can hardly remember what happened 2 o'clock in the morning a year ago. Mr. Speaker, we came to this government in 2018 resolved that we would do whatever is required to deal with the inefficiencies and the inadequacies of the criminal justice system. Let me share with you, sir, some numbers, and you can find these numbers in the reports of the Judicial Council. The statistics I'm going to share, sir, are filings of criminal cases on an annual basis for the last decade. Now, by filing of criminal cases, I'm really saying matters that have been presented to the High Court for trial on indictment. This has nothing to do with the many magistrates' court cases. We're just talking about the High Court and matters on indictment. In 2013, sir, 187 matters were filed on indictment. 187. In 2014, 245. In 2015, 70. 2016, 149. 2017, 386. 2019, 301. 2020, 219. 2021, 307. 2022, 184. And 2023, 72. This statistic is not offered to suggest anything to do with the level of criminality in our society, because as you know, sir, this is not a statistic relating to criminal activity, only to filing the indictment in the court, because an offense might have been committed, let's say in 2014, but the indictment is only filed for any number of reasons. Maybe the investigation is not complete, all kinds of things, but the indictment may only be filed a few years later. So this is not a reflection of criminal activity, this is only a reflection of the act of the DPP of preferring an indictment. But those figures, sir, add up quite quickly to well over 1,000. And these are cumulative, there's a cumulative effect, because in any 1 year, only so many matters will get disposed of. So you're adding year on year to the number of criminal matters that are available to be tried. When we came to government, sir, you well remember that there were 2 High Court judges. 2 High Court judges. Now, sir, in 2017, I told you that 386 matters were filed on indictment, and in 2018, 203. You only had 2 High Court judges. So in those 2 years, sir, you had just shy of 600 indictments filed in the High Court, just those 2 years, but only 2 High Court judges to try them. And that's just a snapshot of 2 years. That does not rake into the equation those you left undone from the previous years. It was obvious to us, Mr. Speaker, that the first thing that we had to grapple with was strengthening the judiciary. Strengthening the judiciary. And we immediately set about changing the Supreme Court of Judicature Act to increase the number of judges. And I should also remind you, sir, that in 2018, we had the practice of not having a full-time criminal division. So, as you well know, Mr. Speaker, a particular judge would be doing assizes at a particular point in time. After 3-4 months, they've gone back to be doing family or civil or whatever it is. That weakness, of course, meant, Mr. Speaker, that a judge really could not develop the level of expertise that he or she needed to develop in the criminal media, simply because they would be in the criminal media for a couple of months and then you're gone. You may get rotated back in 2 or 3 years. That was a weakness in the system. I can tell you that as far back as when Sir David Simmons, I apologize for calling his name, but it is not in any demeaning way. Former Chief Justice Sir David Simmons implemented 2 initiatives. One of them had to do with removal of committal proceedings. Now, sir, you've been involved in all committal proceedings, and you know a committal proceeding can last for months, if not years. We've moved to paper committal, which means that the magistrate gets the papers and makes a decision, and it moves into the system faster. He also abolished the assizes, and so we now have continuous assizes. But those things of themselves, while they were helpful, they were not successful, sir, in breaking the backlog of the delays and the increasing number of cases that were stacked up waiting to be heard. So that's why our first initiative has been and was to increase the number of judges. But we also codified the concept of a criminal division so that a judge is appointed to the criminal division. That is where you sit, that is where you work every day. You're not going to be doing family come December. You're not going to be doing civil matters come December. You are in the criminal division. And you work in the criminal division. That was an important initiative, but instead of just having 2 judges and the permanent complement of the criminal division, we increased that to 3. And then we doubled down, Mr. Speaker, by appointing 2 further temporary judges. So we effectively moved, in 2018, the number of judges doing criminal matters from 2 to 5. We had COVID, and that impaired a lot of what was happening, but even during COVID, I have to compliment the judges, they still managed to get matters moved through the system. In 2022, sir, we increased the number of judges even further by appointing a further 3 criminal judges. So in the short space, Mr. Speaker, of 4 years, we increased the criminal bench of the High Court of Barbados from 2 judges to 8. Now, Mr. Speaker, we are seeing the benefit of that increase every single day. Yes, we still have challenges, but the number of matters that are moving through the criminal bench is phenomenal when compared to when we were just limping along with 2 judges. What else did we do, Mr. Speaker? We've agreed to the establishment of a post of Deputy Registrar Criminal Division. And the Ministry of the Public Service is busy trying to complete that recruitment. And the purpose of that registrar, because if you have so many cases moving through, somebody has to manage the pipeline. In the same way that we have masters in the High Court and registrars. We've determined that a registrar criminal will be the individual who is responsible for managing the pipeline of the criminal division and help to take some of that admin work off of the back of the judges. We increased the number of judicial assistants, Mr. Speaker, and that helps to take pressure off of the judges as well. We've also introduced new technology called voice writing to replace the transcription that we used, and we still use it. Now, for those people who would not know, judges used to write down every single word that was said in court. So if you have 8 days of testimony, everything that is said, the judge had to write down longhand. Every single word, a most torturous exercise. And if he wrote badly, I could never be a judge, sir. Because I can't even read my own handwriting sometimes. But those were the realities that we had to face. And then somebody had to go and sit down after the trial and type out all that evidence. It was a crazy system, but it was what we had. And then we moved to transcription where, you know, the individuals would, it's the kind of thing you used to see on Perry Mason, the person with the stenographer would sit there and type up the thing, and you would have it available to you immediately. But we've changed that now, sir, and we're transitioning to something called voice writing, which is a new technology, but very much in vogue and used across the world. And we have increased the number of individuals in the transcription exercise from 15 to 37, sorry, from 15 to 27. 27, from 15 to 27. So, sir, we're doing, I mean, obviously you appoint more judges, so you need to have better transcription services. So we've taken a lot of initiatives. But, sir, what was obvious to us was that as an administration, while the responsibility was ours, we had to have a sensible dialogue with the stakeholders. We had to have a sensible dialogue with the stakeholders. And, Mr. Speaker, last year in May and June, we had a 2-day criminal justice symposium. It was participated in by judges. The bar was the heaviest set of participants. We had civil society, we had the government side, we had the police, everybody who had an input, probation, all of them, who had an input into the criminal justice system were invited to be and participated in that process, sir. The churches were there. And the churches asked, well, we'd be happy to come, but why invite us? We said, because you have as much a stake in this as we do. So we want you to be a part of the process, because you are either going to be involved in keeping people away from the system, helping to counsel people who are in the system, or helping people to adjust when they're on their way out of the system. So we had the churches, everybody came to this symposium. Mr. Speaker, we had a number of papers presented. It was really a very good session, a very good two-day session. It was rough along the way because the bar didn't pull any punches. The DPP didn't pull any punches. The only people who I think pulled punches were the judges who, by convention, are not inclined to be combative in public arena. But that particular symposium, Mr. Speaker, allowed us to focus on what the issues are and to help to form a consensus on what improvements were needed. Mr. Speaker, there are a variety of things that the symposium gave rise to, that we needed new criminal procedure rules. Those have been completed by the Law Reform Commission and have been sent to the Bar Association for comment. So that is moving along. We expect that that work will complete by the end of summer, and by the start of the new court year, we should have new criminal justice rules. And just for completeness, let me say, Mr. Speaker, that even though we're putting those rules in place, we're not putting them in place without training. My ministry is already committed to funding the training that is necessary. Mr. Speaker, if you show up in court in September, October, and you know got to deal with new rules, well, you got to spend as much time working through the rules as you do preparing for your case. That's unfair to everybody. And therefore, we want people to be engaged in working through the rules, getting to understand how they work, both on the government, the DPP side, and the private bar, and the judges, so that these new rules become a benefit to the system. We're also going to be introducing plea bargaining legislation, Mr. Speaker. This is another initiative that we felt was important. Right now, we have no structure for plea bargaining. There's no structure for it. You can hopefully convince the DPP to offer a lesser charge if the person plead guilty, but there's no structure, there's no teeth to it. There's nothing that you can hold somebody to. So DPP may say, are we withdrawing these charges and we're going to bring new charges, and then the fellow says, still say not guilty. And what have you done? So that is another mechanism that we're going to put in place. That legislation the draft is virtually completed. I expect to be able to certify that within the next 2 weeks or so, and then it will come here for laying. But today, sir, we're dealing with judge-alone trials. Judge-alone trials. I'm happy, sir, to say at the outset that two very strident voices, people who are able to speak authoritatively on the behalf of the Democratic Labour Party, have come out and supported the judge-alone trials. But I'm not surprised, because both of them were present at the symposium. And they participated fully in the discussions, and they gave the imprimatur to the decision of the symposium to bring judge-alone trials into the system on the condition that accused persons would elect. So I'm happy to know, sir, that on this particular matter, I believe that some people from across the aisle are supportive of it. We will wait to hear what the official position of the official spokesperson of that party is today. This legislation that we have brought, sir, is intended to help the system be more efficient, and there are a number of advantages. One of the advantages, and sir, we're not inventing the wheel here. Across the region, Trinidad has judge-alone trials. I think there are a few other jurisdictions that have them in the region. They've been working very well. And the judge-alone trials, the first judge-alone trial I think Trinidad had came during COVID, and it was a murder trial. Fella got off on a murder trial. So it is something that is tried and proven. But the history of it, sir, is worthy we can't just gloss over it. Going back as far as the Magna Carta, sir, it has been a foundation principle that a man should be tried by a jury of his peers. He should be convicted only by a jury of his peers. That's probably the better way of expressing it. And sir, that has been one of the pillars of our criminal justice system. Of course, sir, that rule does not apply to the magistrate's court, where every day, all across Barbados, magistrates sitting alone determine innocence or guilt, sometimes in matters that are fairly complex. You remember only too well, sir, that many of a matter is treble, as they say, either way. So the accused gets to decide, do I want to be tried for this offense in the magistrate's court, or do I want to be tried for this offense in the high court? Same offense, sir. Same facts. Same offense, same facts. But he can elect whether he wants to do it in the magistrate's court or in the high court. If he does it in the magistrate's court, his guilt or innocence is determined by a magistrate. There's no jury. There's no jury. If he does it in the high court, there's a jury. But the point is, sir, I'm trying to establish in the minds of the chamber and the minds of our listeners that we currently have a system where innocence or guilt is determined by a single arbiter in the absence of a jury. And nobody has complained that justice is not being served. So it is not so alien a concept to us. But in the High Court for indictable matters, a trial by a jury of your peers is something that has been axiomatic. Now, sir, I was talking about the advantages to the system of jury trials. Sorry, to having judge-alone trials. One of those areas, sir, has to do with the fact that typically judge-alone trials are faster than trials with jury. They're more efficient than trials with jury. They eliminate at the outset the selection of the jury. As you well know, sir, when you begin your case, the first thing you have to do is to empanel a jury. And you know what that is like. The system of objections to jurors, all of those things have to be gone through. No, I wouldn't suggest at all that our system is anywhere like the one with the President of the United States, where that took almost a week. But it still takes time to empanel a jury. And of course, the jury system is also going to be coming up for review very shortly. Cabinet will, either this week or next week, have the opportunity to weigh in on the policy decisions. But the point is, sir, that with a judge-alone trial, you eliminate that apportioned time for the selection of a jury. But it also eliminates a lot of the time that you lose when you have voir dires and so on, where the jury has to go out and you make certain decisions. All those kinds of things you get rid of. And of course, sir, you get rid of the fact that there's no jury to retire to come up with a verdict. So judge-alone trials are typically faster. They're also less expensive. Now, sir, I can tell you, I've received a complaint recently about from a commercial enterprise in Barbados where one of their senior staff was on jury duty and was on jury duty for a period of about 4 months. 4 months away from the workplace. No, it may be, I'm simply trying to suggest that jury trials take up a lot of resources. They take up the resources of the individuals who have to leave their workplace and come and sit on a jury to determine innocence or guilt. I'm not suggesting at all that that is not a valuable exercise. I'm just saying that it is an expense that has to be factored in. We, of course, pay the jurors so little for serving on jury duty that I wouldn't even want to presume to suggest that that is a saving. In due course, I'll be asking the Minister of Finance, though, to agree that for those individuals who serve on the juries, that we should pay them a little more, sir. I think the current amount of money they get is $10 a day. I don't think the Minister of Finance heard. If you don't mind, sir, I'll say a little louder. The current amount of money that a juror gets is $10 a day. And you show up at the court in time for 9 o'clock. And you sit there until 2 o'clock in the afternoon, $10 a day. It's probably like $1.08 an hour. So we have to consider, sir, you have to consider that needs to be looked at, but I will make that petition another time in another place. But there's the savings that you get from that, sir. In addition to that, sir, the benefit of a judge alone trial is that you have the expertise of the judge. Now, sir, it is a difficult marriage, and I know you see it every day. When you have a complex case, and even if it's not a complex case, trying to explain to a juror, these are matters of fact on which you get to decide. These are matters of law on which I get to decide. And sometimes my decision on matters of law will influence how you can consider the matters of fact. You really have a system that has some built-in complexities. How many times, sir, have you seen a judge struggling to deal with the issue of corroboration? You don't have to corroborate, but if you don't have it, it's unsafe. And the poor juror trying to figure out, what he just say? It isn't so easy, sir. And therefore, because judges are legal experts and have a firm understanding of the law, in circumstances where the jury has none, you can get a sounder decision coming from a judge alone in those circumstances. But sir, the one that I think would immediately resonate more with individuals is the effect of bias. And I don't mean bias in the legal sense. I mean bias in the sense that jurors are human beings, and they take into account, for better or worse, things that, when you look at it, you say to yourself, how is this fair? So imagine a clean-cut young man who shaves and so on, and he looks very decent, and he got on his Harry Potter glasses, and he goes before the jury, and when the jury says, oh, he looked like Alfred that he used to teach in Sunday school. He was a nice little boy. Those are the kinds of things, that will come into play, which have nothing at all to do with the evidence, but jurors develop a unique perception of things sometimes from the very early. But equally, a fellow who might be totally innocent comes into court, but he look a little thing, and a juror says, he too ugly though. And immediately, there's almost something coming through you to you, Mr. Speaker, where you say, oh Lord, this fella, that particular juror, she don't like my client at all. And you can sense it. And therefore, sir, while it is possible for judges to have that kind of attitude too, they're better able, Mr. Speaker, and this is established, they're better able to put those things aside and to make a dispassionate decision on whether something meets the burden of proof and the standard of proof that is required. Now, sir, there is the downside. There's the downside. Sometimes jurors have a keener sense of societal issues than judges might. I believe that we are past the days of our judges coming only from the cloistered environment of the upper class of Barbados. But the fact is that, people who are serving on the bench are not necessarily people who stop in Baxter's Road at night, or who go in Oystins for a fish cutter, or who can stop when the fellas gambling on your street light and have a chat with them. So a judge alone trial will have the downside of eliminating some of the diverse social perspectives and experiences. But equally then, sir, you say that the juries can be biased, but sometimes the judge can be biased too. There was a known former Chief Justice of Barbados of some renown who, I was told, I believe the deputy clerk would have been told this too, that he said, now these lawyers here could come and eat at my mahogany, because he came from a particular class, and therefore brought certain intrinsic prejudices with him. So there's a downside and there's an upside, sir. It is important for juries to have a role in the judicial system, in the criminal justice system, because juries have to play a part, and therefore removing the opportunity for them to participate in the jury robs them of that chance to participate in an important exercise. So there's a balance in that. And that is why, sir, perhaps why the decision coming out of this symposium was that we would have a system of judge-alone trials which is elective. Elective. And therefore, in this bill, Mr. Speaker, it provides every person against whom a bill of indictment has been preferred shall, subject to the provisions of this act, be tried by a judge sitting with a jury. So I'm going to break this down, sir. This act says, you shall be tried by a judge sitting with a jury. So it is establishing that this is your right. This is your right. We're not taking anything from you. This is your right. But we go on to say that it is unless he elects to be tried by a judge sitting alone. So you have the right, the inalienable right to be tried by a jury of your peers. But you also have the capacity, Mr. Speaker, to say, to make a conscious decision, I do not want to do a jury trial. I prefer to have a judge. And Mr. Speaker, I'm sure that in your practice, while you've not had this opportunity before, I believe you would probably be able to think of many instances where you would much rather not risk your client going before a jury. Because sometimes the combination of fact and law becomes so complex that you really wonder whether the jury understands it. And therefore, you may prefer on a very technical matter to rely on the intellect and disposition of a judge alone. So this, I reiterate, reaffirms that every accused person on indictment has the inalienable right to a judge and jury. So it is inalienable in the sense that inalienable in the sense that we can't take it from you. But you have the right, if you desire, to ask for a judge alone to do your trial. Now, sir, the act in itself is not too complicated, but I'd like to highlight that where a person, upon being arraigned, elects to be tried by a judge alone, the court then has to make a decision as to whether to allow that. So the court gets to use its discretion. But in using its discretion, the court must be satisfied that the person has sought and received legal advice from an attorney at law in relation to a trial by a judge sitting alone. So he must have received legal advice from his attorney or from an attorney on exactly what a trial by a judge sitting alone is. What does it mean for him? What does it mean for in terms of his rights? So he gets to make that decision, and he has to file a form. And it is called Certificate of Waiver of Legal Advice, if he does not have legal advice, or Certificate of Confirmation of Legal Advice. So in other words, sir, a person who says, upon being arraigned, I want to elect to be tried by a judge alone, the judge has the power to order yes or no. But should the judge be disposed to order yes, the judge must satisfy himself, sir, that the individual has received legal advice from an attorney in relation to a judge sitting alone. Now, a person may decide to waive, sir. I'm sure you've been in court sitting where a fellow said, I am defending myself. And sometimes they win. Sometimes they win. So an individual who has taken the decision to defend himself, to tell him now that he got to go and find a lawyer to advise him on where to do a judge alone trial, really makes no sense. So you have built into the procedure a power of the individual to say, I waive my right to legal advice on this matter. I understand it myself. I don't need to go and pay a lawyer to tell me what I already understand. So the person can waive the right to legal advice, but if they do, they have to sign a certificate. If they get legal advice, they also have to sign a certificate confirming that they have received legal advice. So the matter of a judge alone trial is not one that is done lightly. The act says, the bill says, the court shall not proceed to try the person by a judge sitting alone unless it is satisfied that the accused person understands the difference between a trial by judge sitting alone and a trial by judge sitting with a jury. That's key, sir. The judge cannot do a trial by himself alone unless he is satisfied that the accused person understands the difference between the two. This is especially important because we want to make sure that no advantage is taken of an individual, sir. Now, the accused person can change his mouth anytime before the trial starts. And this is also provided in the Act. An accused who is elected for a trial by judge sitting alone may withdraw his election before his trial begins and elect to be tried by a judge sitting with a jury. Now, Mr. Speaker, you're well aware of the process. You first go to court and you get arraigned. How do you plead? Guilty or not guilty? And at that stage, he's given the option. I want to do a judge alone trial, or I don't want to do a judge alone trial. Now, as you know, Mr. Speaker, the trial doesn't start that day. The trial doesn't start that day. It is then adjourned for trial. And therefore, at any time before the trial actually starts, the accused person can say that I changed my mind, Judge. I want to be tried by a jury. And the judge must allow the person to take that particular course of action. But it may also be the other way around. The person who might have elected to be tried by judge and jury may change his mind, and as long as it's before the trial starts, he can then say, I want to do judge alone. Mr. Speaker, a large set of the amendments here are consequential because we're now talking about adding judge alone trials. So where you have provisions in the Act which dealt with jury, you don't have to make technical adjustments to be able to allow for those things to happen where there is a judge alone trial instead. The Act itself is not complex. As I said, Mr. Speaker, the decision to do this came out of a symposium on criminal justice reform. It has received the highest support from two ranking members of the Democratic Labour Party, given very publicly. I was very pleased to see that they supported this measure when they spoke to the press about it in the last 2 or so weeks. But in addition to that, sir, I don't want to say took the precaution, I followed the wisdom, Mr. Speaker, of sending the draft bill to the Bar Association and asked that they consider the draft bill and let us have their comments. The criminal section of the bar looked at the draft bill, they made their recommendations, there were no major issues. Those things that we could accommodate, we did. Those things that we disagreed on, we did them. But there's really no light between us on this particular issue. And when that consultation was finished, Mr. Speaker, and the new bill drafted, the amended bill drafted, we then took it to the Criminal Justice Reform Committee. Now, Mr. Speaker, one of the important institutions that came out of our Criminal Justice Reform Symposium last year was the establishment of a standing committee called the Criminal Justice Reform Committee, chaired by the learned Chief Justice. And that committee consists of two members of the criminal bench, consists of the DPP and the Deputy DPP, the Attorney General and Minister of Legal Affairs, the Minister of Home Affairs, the Commissioner of Police, the Superintendent of Prisons, the Head of the Probation Department. Those are essentially the people who are part of this Criminal Justice Reform Committee, and from time to time the committee co-opts people and gets papers and presentations from people and so on. This committee has been working very hard, sir, and a lot of the reforms have been going through the committee. We now have a new chair since the appointment of a new Chief Justice, but I expect that he will take up that particular mantle and move it further forward. But the point I'm making is, sir, that even after the symposium and we got the policy direction from Cabinet, we did the draft, we went back to the bar and said, tell us what you think. They have submitted their views. We have incorporated as many of them as possible. And then we took the bill to the Criminal Justice Reform Committee chaired by the Chief Justice to get its final imprimatur. This bill has gone through a significant degree of consultation, and I'm satisfied, sir, that what we have today, it not only fits the bill, it has the potential, if it is used, and we hope that it will be used by the criminal bar, has the potential, sir, to get rid of some of the backlog in the criminal justice system. And, sir, it has the potential also, to ensure that, that we are able to save some costs, even though the cost issue is not a major determinant. I commend this bill to the chamber. It is new, sir. As I said, since going back as far as the Magna Carta, the right to be tried by a jury of your peers has been a cornerstone of the criminal justice system. But we have to look at these things in many perspectives. The perspective of Canada, sir, is that an individual has the right to choose between a judge-alone trial or a jury trial. But they express it a little differently. They say that an accused person who does not want a jury trial will not be forced to have one. No, it takes you to the same place. But the attitude of the system is a little different. They're saying, if you don't want a jury trial, we will not force you to have one. We're saying, you have the right to a jury trial. If you want to elect, however, we give you that right. But our approaches are a little bit different. In Australia, jury trials are common, but equally common are trials by judge alone. Let me say one thing on the matter of elections, sir. And no, I don't mean the general election. I mean the matter of electing to choose judge alone trial or judge and jury. Trinidad, when they enacted their legislation, took the approach that we are taking. That is, that you can elect. And by the way, sir, we've decided in our legislation that treason will always be a jury matter. That is a policy decision. Treason will always be a jury matter. And the truth is, I don't know if we've ever had any treason cases in Barbados, certainly not in living memory. The history books don't reveal that, though some people, I guess you would jokingly say that they've been treasonous, but not requiring any kind of trial. But sir, so Trinidad took the approach of having the accused, giving the accused the right to elect to have a judge-alone trial. From the outside, it appears to me that Trinidad was not happy with the take-up or the uptake and wanted to go a little further and say, you know what, some of these matters are so complex that we're not giving you any more option. We are saying any of these particular category of matters, you must do judge alone. And that's done in some jurisdictions, sir. For very complicated matters, judge alone, we're not wasting time with the jury on this one. However, when they tried to pass that legislation, sir, there was a loud hue and cry. Or as some people in some constituencies would say, there was a loud human cry. So whichever you want to call it, sir. A loud human cry or a loud hue and cry. That is what happened in Trinidad. And the bar, civil society, everybody jumped up in arms and said, we're not going to agree that a government can force people to do a judge-alone trial. That should be a matter for the accused. The right to a judge-alone trial, to judge and jury trial, is so enshrined in our psyche that we can't allow you to change it. The legislation was not pursued. That is something that I'm only mentioning it, sir, for what it's worth to the chamber. We are not going there. We are saying you have the right to decide how you want to be tried. Mr. Speaker, will it bear fruit? I believe that it will. Of course, sir, I can neither speak for defense counsel, nor can I speak for an accused person. But for sure, sir, this bill does not take away the rights of any accused at all, not in the least. The accused loses nothing by this bill. The accused, however, gets the right to make a judgment call on whether he wants to put his future in the hands of 12 jurors, or 9, whichever it is, or whether he wants to put his future in the hands of a single judge. That is a deeply personal decision. But I believe, sir, that given our makeup on the bench, given the temperament of the judges in the criminal bar, and given the level of expertise that the senior members of the bar will, I think I confused myself, given the temperament and intellect of members of the criminal bench, and given the vast experience of members of the criminal bar, I believe, sir, that we will see that in at least some cases, individuals, accused persons will be bold enough to say, I want to do a judge-alone trial. I believe, sir, that justice will be served. And as I said, the first judge-alone trial they had in Trinidad was one during COVID, and it was a murder case. And it made sense during that time because empaneling a jury was a near impossible thing. In fact, sir, for the 2 years of COVID, we could not do jury trials. Couldn't do jury trials. And this whole issue of judge-alone trials was raised with me back then because we didn't know when we were going to get out of COVID, and we couldn't allow the judicial system and the criminal justice system to grind to a halt. Our judges still worked. Our judges still disposed of hundreds of matters. I think in the first year of COVID, they got rid of over 200 matters, and a similar amount in the second year. So there are a number of factors which perhaps have brought this initiative to the fore, but the most important one now, sir, is the hope that it will help to break the backlog of some of the other matters of the backlog in the judicial system. Mr. Speaker, this administration has received nothing but praise for the initiatives that we've taken in respect of the criminal bench. The appointing of judges, sir, the appointing of additional judges has been of enormous benefit to the system. The only challenge that has arisen out of it is the fact, Mr. Speaker, that the criminal bar now has to keep up. When there were only 2 judges doing criminal matters, the lawyers could say, well, before this judge, before that judge, you control the thing. You control the thing. But now that we have 8 criminal judges on the criminal bench, sir, it's a little harder to do that. And the matters are coming fast and furious. And one of the things that the Chief Justice, twice removed, spoke publicly about was the importance of having additional practitioners getting blooded in the practice of criminal law. We can't tell people what law to practice. That's a deeply personal choice. I myself had a little stint in the criminal arena. The last criminal case I did was representing one of the accused in the Garns murder. Erling Garns, sir. I think I did that case in around from Sweetwater. I did that case, sir. I think it was about 1992 or 1993. And therefore, sir, that is the last time that I set foot in a criminal court. It wasn't because he was found guilty. They were all found guilty, sir. And you would recall, sir, that there were some doughty campaigners In that trial, we had Waldo Ramsey and former Prime Minister, member for St. Philip, former member for former Prime Minister for St. Philip South. He also represented one of the people in that case. The point is that has been last I set foot in the criminal court. But the point is, sir, that with 8 judges, pressure is going to be on the senior practitioners to let some of the juniors face some of the music. That is the only way. That is the only way that they're going to learn, sir. And I know that you have that particular bent, and that you teach them, that you're learning them how to swim. Throw them in the water and then get sure how you can. Justice is still served, and I know that you supervise your juniors, but if nothing else, so I want to make a call though for an increase to the number of lawyers practicing at the criminal bar, because, sir, with 8 judges, we've done all those things. The 8 judges are very comfortable in their various quarters. They have everything that they need. But if we do not have enough lawyers to help us get through the cases, then all of our efforts at breaking the backlog are going to be in vain, sir. Mr. Speaker, I don't know that I can usefully add anything to this discussion. However, I will be available in the wrap-up to deal with any issues that might arise, and I'm therefore obliged to you for your patience and consideration.
Honourable member, you got to move. Honourable member for saying Christchurch South.
I'm obliged to, Your Honour. When I came here last week, I made the comment, which I will repeat today, that as a democracy matures, we find that debates in this place become less partisan and more philosophical. And today, this legislation again finds itself within that genus of debate. The proposal to give to the accused before a criminal court in the High Court the right to choose for a trial without a jury and by a judge alone. I made some notes, and I didn't intend to begin at the end, but I'm going to begin at the end of my note, and I'm addressing a criminal lawyer. If there are criminal lawyers in Barbados, and